From the Sunshine State, this is Tampa Bay's Tan Talk.
It's time for FLA Law, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. It is Tuesday, and it is time for FLA Law on the radio. We are here live for you here at the WTAN radio studios, here to answer any questions that you may have regarding Florida law. My name is Matthew Noyes. I'm one of the attorneys at the law firm of Perenich, Caulfield, Avril Noyes, the longest established personal injury attorney in law firm in Tampa Bay. We have been helping people since 1955. That means we are celebrating our 70th birthday here helping people. And as a thank you to those who have trusted us for so many years and so many decades, we decided that we should put on this show to be available to answer questions that you may have regarding the law. We are a personal injury law firm. That means we do car accidents, slip and fall, trip and falls, medical malpractice, work injuries, and even Social Security disability claims. So if you have any questions regarding that, please give us a call during this hour radio show, and we'll be happy to tackle the questions that you have. I say we because I am not here alone. I have my friend and my law partner here, Lori Robinson, an old faithful co-host to FLA Law. Lori, good evening.
Good evening to you. It's always a pleasure to sit in the chair here.
Yeah, we get to say good morning, good afternoon, and now good evening
right.
too. That's pretty good. Yeah, Lori and I have been working together. I think just her and I together for about 19 years.
Something in that ballpark,
and
I would
Lori's
say.
been with the firm, I think 27 or 26 years or something.
Yeah,
like
I think
that.
I'm getting ready to enter the 27th year.
Yeah, I think
unbelievably.
so.
I don't know where the time goes.
That's wonderful. Lori is a board-certified civil trial attorney, and she handles all those types of areas that we talked about, whether it's car accidents, trip and falls, Social Security disability, medical malpractice, and even work comp claims. Lori and I are here to tackle any questions that you have. Well, there's 3 ways you can let us know what your questions are. The first and the easiest is just giving us a call. You can call us at 727-441-3000, and your call will be put right on the air, and we'll be able to address the questions that you have. If you don't want to hear your voice on the radio, well, there's a second way, and that is through the firm's Facebook page. We are now live on Facebook. Our page is Perenich, Caulfield, Avril Noyes Injury Lawyers. Perenich is spelled Perenich, and then Caulfield, Avril Noyes Injury Lawyers. And you can type in your question right there on our live page, and I'm looking at the screen right now, and you can see Lori and myself. We're waving to you, but you can type in your question there. We'll be happy to tackle that. That's the second way. The third way is jumping on the firm's YouTube channel, and that, again, is Perenich, Caulfield, Avril Noyes Injury Lawyers. You can type your questions right on our YouTube channel, and Ed on the other side of the glass, our producer, would be able to send us your question over to us, and we can address that on the radio as well. So 3 ways to get in touch with Lori and myself: telephone, Facebook, or YouTube. So no reason not to try to reach out if you have any questions. But Lori, before we take questions, I thought the highlight or the theme of today's show would be, protecting your rights after an injury or disability.
Sure.
In Tampa Bay. And so the first thing I want to really talk about is we are in hurricane season.
Yes.
Of course we're in hurricane season.
We don't want to jinx it. We've been so fortunate.
I am getting on a cruise boat on Saturday and cruising off into the Atlantic Ocean. Down to the Bahamas. And so, of course, there's a storm out there, but I think we'll be
Dennis
all right.
Phillips, so far, nothing to worry about yet. It'll probably be like a front or something that's going to push it up into the Atlantic. I don't know. Right. You might get it.
Rule number 7. I think I'm all right. I'll follow Dennis's rule number 7. But, we've had horrible storms in the past, and people are still trying to make themselves whole because of that. And one of the things that we see in our practice a lot is that when those storms occur, oftentimes the power goes out. Traffic lights go out,
Sure.
but people are still driving on the roads. Can you tell our listeners what the law is about what happens if you are approaching a traffic light and it's malfunctioned because of power outage or just because it's just malfunctioning?
Right. So that's the old four-way stop in that situation, where you sort of, everybody comes to it as if there were stop signs on each leg that's of the roadway, and proceed with the person that stopped first would go, and that. But obviously, the major thing you have to really be looking at in those situations is to really be paying attention, and I would say driving defensively, because obviously people aren't accustomed to that.
Sure.
I remember many years ago, I was actually in San Francisco and I was driving a rental car when the power grid went out west, and it was like the way they're very interconnected. So it was like different. I mean, I'm a Florida girl, so I mean, but I was amazed because that's such a big city, and the lights went out, everything, and it was amazing to me. Actually, everybody did pretty well, but in this situation, you really obviously have to be looking carefully. But basically, it is that four-way stop situation that you would, if you were to come upon that with an actual stop sign, which obviously there wouldn't be one there with the light, but you've got to take extraordinary care. Right,
and that's easier, I should say, if you're dealing with two roads that have one lane. But even on, let's say, Bel-Air and Belcher,
right?
That's not
turn lanes
and everything, and 2 lanes, but the lights on Gulf to Bay and 19 underneath the overpass go out too, or Belcher and Gulf to Bay go out, and then there's 4 lanes of traffic, and you have to rely on all 4 of them to stop.
Right.
And so it is so important. We, in our years, we've helped several, I would say, families that got hurt in car accidents because they stopped, they followed the law, and then they proceeded, but somebody else didn't, and they slammed right into them.
And that's, you always will hear when we are in situations where there may be enough of a storm to have the power go out, the health officials and the other government officials normally will obviously say, if you don't need to be on the road, don't be on the road.
100% correct. Yeah.
Because you can't really, you just can't guarantee how people will handle things, and obviously in those situations. And the other one I always am concerned about, because I have little sports cars, when you get that flash flooding or area flooded roads, where you just can't be sure you're going to be able to get through. And obviously that can sometimes put you in a position where you're kind of blocked off and you don't know what to do. But, I don't, in a sort of just common sense, I guess, but I think the main thing is to recognize the danger, not drive just like it'll amaze me, like when with rain, how people will drive like it's just a normal regular day. It astonishes me, but I guess having spent a lifetime of handling automobile accident cases,
it's hard to astonish us now.
Right. Yeah.
but
I do think about that, so it's, you just really, you have to assume that other people are going to make mistakes. I would say.
I had a prior client call me last month and say that his daughter was driving on Gulf to Bay in Highland. Well, that intersection's kind of messy anyhow because of where you can turn and where you can't turn. Well, the light was malfunctioning, and she got involved in a crash caused by her not stopping. She said, "Well, the car in front of me didn't stop, so I didn't think I was supposed to," and she proceeded. And unfortunately, another vehicle from the other direction also didn't stop.
Oh, gosh.
And so she ran the quote unquote stop sign. He ran the quote unquote stop sign because neither one of them knew what the law is to treat the inoperable light as a 4-way stop. And so that then becomes a question about liability.
Yes.
And if both of them ran the stop sign or failed to follow the law that caused the crash. I wonder if you can explain to our listeners what that scenario would be before 2023
Uh-huh.
and what it is after the law changed in 2023.
Yeah, so we've in Florida have all of my legal career had the concept of what we call comparative negligence. And you can imagine, obviously, in accident settings, there'll be many situations where, you could have maybe perceived the situation a little more clearly, whatever, but the other party was more responsible than you. And so it used to be prior to 2023, March of 2023, the law would allow a jury to consider the percentage of responsibility that they felt should be attributed to all of the parties in the accident. And that, that might be maybe you're 10%, maybe the other one's, 90%. If maybe there are 3 or 4 cars and they could divide all of that up. And then if there was an award of damages, what would happen is the percentage that you are responsible for would be subtracted from the overall award. So you would not receive an award for the percentage the jury had assigned to you, but the percentages that were not assigned to you would be able to receive the award in that setting.
Right. So it's holding the person accountable for their negligence, but only to the degree of their negligence.
And so that was the idea, which seems kind of a fair way to do it. But there was a change in the law in March of 2023 that created a situation where if you are found to be more than 50% responsible, meaning 50.5% or 51%, in that scenario, the law eliminates any ability to recover for your damages at all, even though perhaps the other party was 49%, let's use that, and you were found to be 51%, but the other party obviously had a very substantial role in the accident. In the earlier law, then that it would have been possible to just portion it out just like a jury had. Unfortunately, now that the bar has been set much higher, and if a jury were to find that you were more than 50% responsible, then in that scenario, you wouldn't be able to make any recovery at all.
Zero.
Yeah.
No accountability for the other person's negligence.
Right. Now, let me just throw into this, though, with a lifetime of being a lawyer, practically. That's what I love. I love to debate. That the reality is you ask yourself, well, how the heck does anybody decide that you're 49%, 51%, 40, some percentage? How does that line up with really anything? And the answer is, well, it really doesn't. It's a jury of 6 people in Florida for an auto accident type of case. I mean, that jury is going to hash it out and try to come to some conclusion with the 6 people that they can all agree on. And so however they do it, that's how they do it. They assign whatever percentage they want. So you can't and should not draw the conclusion if somebody says, and actually I'm going to say a lot of people will kind of internalize guilt almost when you're in an accident. I had a friend who was, she had an accident coming through that Ulmerton intersection, and she was making, now she was going from, I think she was coming on Ulmerton and making a left on Belcher, and in that moment, but she had the green turn arrow. I mean, she had a green, and another car blew the red light and collided with her on the side, passenger side. But she, in her own mind, I think there were witnesses, so there was really ultimately no question what had happened. But she wasn't sure in her own mind. She was afterwards. You think, and I think that's kind of a natural reaction. It's like, oh my gosh, because we all can be kind of an automatic pilot. And that sort of thing. Now, the reason I say give that little factual vignette is that if you are in an accident, should not draw any conclusions about what percentage responsibility you might have in an accident if there was some sort of shared responsibility, because it is in the eye of the beholder, and that is the kind of thing that you should seek legal counsel if you've been injured or there's a situation like that before you conclude that, well, it was all my fault or whatever, because may well not have been, because like in my friend's case, she just felt it's shocking to be in an accident, and she just
how'd that happen?
Right, exactly, and that kind of thing. But it is something that's been a significant change in the law, along with tightening up the deadlines for filing a lawsuit. If there has to be a lawsuit, it used to be that you had 4 years from the time of the accident. Now, for a negligence claim, which would include an auto accident, Now it's 2. And so that's, in some ways that might not be bad, actually, truthfully. I mean, most people would like to get their matter concluded. So it's not bad, but it does, it puts a little bit of pressure that in some ways could interfere with what I would call the service of justice, because sometimes there are circumstances where a person doesn't necessarily perceive the need for legal action right away.
Sure. And there's other situations. Let's say that they get in an automobile accident and they hurt their back and they try the chiropractic care, then they try the injections route and physical therapy, then they try the injections. Then ultimately they say you need to have surgery.
Yes.
Well, that may be a year and a few months after the accident. Well, it takes a while to recover from the surgery. If you have to file the lawsuit within 2 years, you may not have a full appreciation of what your damages are going to be.
That's probably maybe the worst part of it. That's a good point, because I always remember many years ago I had a case where the client, lovely lady, we were in a mediation to settle her case, and it was an auto accident, and she had a herniated disc and had significant issues. I'm sitting with the client, and her husband says, now, whatever her name was, lovely lady, he said, now, let's just say Jane, tell Lori how you drop things. And she's, I'm just clumsy. No, she was actually having the kind of nerve weakness that is associated with a herniated disc pressing on the nerve, that is a situation that could indicate surgery.
Right.
And it did indicate surgery. And in her case, ultimately, she had to have the surgery. And fortunately, it was a very successful surgery for her, but it was a very major surgery. And it made a huge difference in the overall value of her claim. And thank goodness it came up. And that's a classic example. You're quite right. The classic example that if that hadn't had the longer time really to sort of play out, she would never have known. If the case had been resolved without that being known, she would not have recovered anything near to the full value of the damages she'd sustained. And of course, you never really recover the full value because of the nature of things, but you certainly want to be taking into account everything that is going to be a significant part of it. We would prefer that it was a little bit longer, and a lot of good arguments for that. But it's not. So if you have something happen, you don't want to dawdle about getting some legal advice about it so that it can be evaluated and your rights are properly secured, along the way. And, you get guidance on. And a lot of people, probably the biggest thing we see are people that don't really want to go to the doctor, which I would certainly count myself in that category.
Me too.
Yes. And so if you kind of keep hoping that it's going to be a little better. In a way, the lady I was describing, she had gone to the doctor and she'd received a lot of supportive care, but she was kind of minimizing what was going on, which again is human nature, understandable. You don't want to think you've got a more serious problem.
And she probably grew accustomed to that.
Yes.
We have a lot of clients that, our theme in some of our trials is that they have to live their new normal.
Right.
I think our minds train ourselves not to remember bad things.
Right.
And so they forget that they used to be able to ride roller coasters, or they were able to open up a jar or carry things without dropping them. And the injury is something that they sometimes minimize. And that's why it's so important, that in your example that we had the husband that helped out. But that's why we always talk to family members too, because we always say that an accident just doesn't impact the one person. It impacts the whole family.
Yes.
Whether it's the kids or the parents or the spouses and such. So
right.
It is so important that you talk to an attorney to get your legal rights understood, without, you can Google it. AI nowadays can probably tell you, but Dr. AI and Dr. Google probably aren't the ways to do it.
Very dangerous, because I'm starting, as I get a little bit more into this AI stuff, it can be very helpful. Like, you do a Google search and now it'll kind of give you a little summary of the answer, but it's not as good as we think it is. It's a great tool. But there are situations people probably heard about, what they call it hallucinations, where the AI will actually make up stuff. So it's a good tool to get kind of a start, but if it's something specific, you really need to drill down. And I would say, we probably will talk about this later, but are different areas where we do a lot of Social Security disability.
Sure.
I Googled a question just for the heck of it that I knew the answer to, kind of, but I kind of wanted to have a little refresher, and it was wrong. And I knew it was wrong. Yeah. But I could see how in a search where, the computer is just really trying to find the words that go together on a particular topic. Well, Social Security is a classic example. You go to their website. That is so convoluted, something very straightforward and simple is okay, but there's very little that's very straightforward and simple.
Anything?
Yeah. And
How
so,
do you spell Social Security?
yeah, no, but it's very interesting. So I'm sure people today, and they'll be more and more inclined even to think, well, what's the value of my case? And to be inclined to think, well, maybe I could try handling my own situation for a little bit, see what I can do with it. And it's not, it's an area that any legal area, frankly, I would tend to feel that way. But I certainly, the ones we know a lot about, which is the personal injury and the Social Security, it's a little deceptive. So it's a good way to get a start on information. But
we are bombarded with companies that say, hey, we can do your AI summaries of medicals and do your demand letters for you and such like that. We're putting them to the test. I don't think I talked to you about this just yet, but there's two companies that really want our law firm's business. And so we're going to submit the same material to both companies.
Oh, that'll be interesting
to see how the results differ.
Yes.
And we will do our own summary of it. So we'll have an idea of what the real truth is about the summary.
Yes.
And we'll see how they are.
Yes, that would be good, because it's a great tool to kind of, we see the medical records will be so voluminous.
Right.
Obviously, would be wonderful to have the help of being able to get summaries that make it a little easier to be more efficient and things, and even probably to do like an outline maybe of a settlement demand that you could then look at and basically be sure that it's what you want. But because that human element is it's not well replaced. Now, maybe I'm even at Publix now, they have all of those self checkouts, and I happened to go like on a Saturday morning where they only had like 2 actual lanes where they had people, and I'm a little bit, I suppose I could do it, but I don't like it.
That's right.
I don't like it.
I'm paying these prices so you can pay your clerks.
But you can see where that it's a lot of things are moving much more in that direction, but the personal element, including, I would say, part of why it's so important for people to talk to an attorney that handles personal injury claims is that I know you're the same way, from a personal point of view, a positive can-do attitude is the way to go. Do not want a person to dwell on, the pain and the differences in their life. Certainly from a personal point of view, you don't want to focus on that, which is why over the years, we know in talking with people how to kind of draw out what the situation is that is a part of their new normal that is so different from what they were, so that a claim can be made on their behalf that actually does reflect what's occurred.
Sure.
So I always tell people, sometimes have them do a little journal or something, but don't do it if it's going to depress you.
That's right.
Really. Because having done this for many, many years, we really can get a pretty good handle on what's going on by asking the person, in a in-depth interview.
Yeah, if you have a conversation with them, you have an idea. And then if you have a conversation with their loved ones,
yes,
you have a good idea.
Even more so there, because often you won't have the perception of yourself that someone that knows you well will.
So an AI summary of medical records that may talk about changes in lifestyle doesn't have the same impact as if you talk to them.
Helpful tool for us in putting things together, but it can't actually it can't replace the human element.
It has to be the right tool. A hammer is a wonderful tool, but if you're trying to screw in a bolt, it's not going to do you any good. So
and we pride ourselves on actually very individual personal attention. They're the large, big firms that we're not small, but we're not large.
Right.
Really, we can give the personal attention without someone being kind of as one of many cases.
And not to toot our own horn, but we have been doing it for 70
Yes,
years.
that's
We're
true.
doing something right for 70 years. And I think it's because we put the client first.
Yeah.
We don't put the case first. We put the client first.
Yes.
And I think that's important. So I am Matthew Noyes. If you're just tuning in now, you're listening to FLA Law on the radio. I am Matthew Noyes. That's Lori Robinson. We're two attorneys at the law firm of Perenich, Caulfield, Avril Noyes. We are the oldest, longest established personal injury law firm in Tampa Bay. We've been around since 1955. But today, right now, we are on the radio live for you to answer any questions that you have. 3 ways to get in touch with us. Give us a call at 727-441-3000 or jump on our Facebook page live. We are live right now at Perenich, Caulfield, Avril Noyes Injury Lawyers. Perenich is spelled P-E-R-E-N-I-C-H. Or a third way is to jump on our YouTube channel. We are there live as well. And you can type in your question right there, and we can tackle any questions that you have regarding personal injury law, workers' comp, medical malpractice, and even Social Security disability. If you're listening to us after the times between 5 and 6 on Tuesday, you're probably listening to us on our podcast because we upload every episode after our live show onto the podcast platforms. So you can never have to worry about missing any episode of FLA Law on the radio. So, Lori, before we take a call, why don't we talk about, we were talking about the comparative negligence and how it relates to auto accidents, but it's not just auto accidents. It's also trip and falls and slip and falls.
Right.
If we have a trip and fall case, oftentimes you're going to hear people say, well, gosh, you should have seen where you were going. That puddle was so obvious, or that pothole was so obvious. And the comparative negligence argument comes into that as well.
Yes, and those trip and fall, slip and fall cases have always been a challenge in terms of legal negligence cases, because that will always kind of lend itself to an argument on the side of the defense or the premise, that the incident has happened at. But again, just as I was saying about the auto accident situation, there's no precise way that the percentage of responsibility is established. And so when we have a personal injury case, and there's so many different scenarios, like with the trip and fall setting, it may have, a lot of times people don't really even know what they slipped on, but they know they slipped. And so we get involved at that point. Obviously, we have to do investigation and try to figure out, well, what happened? Was there something about the way the floor surface was maintained? And, there are many different factors that can come into play that are such that an establishment should, in the exercise of reasonable care, have been more careful and should have known.
Yeah, one of the things we have to prove is how long the foreign substance was on the ground. Many
times, it's obviously fairly common to have something happen in a grocery store setting where you slip and fall, and we have to be able to show, and this has always been true, that that whatever is on the floor that caused the fall was there long enough so that the owners in the store, in this particular example, really had time enough to know about it and do something about it. Or it may be a situation where and many times the situation where maybe something about how they were operating, maybe they were stocking in the area or something, so that they actually created the actual hazard that led to a fall. But in some way, you've got to be able to show negligence. And a lot of times people will really think that the question is answered by the fact that they simply,
just because I slipped and fell, they had to be at fault.
Right. That they're responsible, but it's not no fault here. You have to actually be able to show that they were responsible. And then there has to be, if the case went all the way to a jury trial, then the jury is going to be allowed to decide, was the establishment negligent? And if they were, did you also have some share of that negligence? And then what percentage would they assign? And if they were to assign more than 50% to the person who fell, then there will be no recovery. Yeah.
Right.
But having said, so we don't like that. It used to be the way that it was. We just discussed regarding an automobile accident. It used to be that if there was, say 50-50, because you could see where jury might say, I really don't know. No, I think they both were equally responsible. Well, in that scenario, then the person would have been able to recover 50% of the overall award of damages, which would be the percent attributable to them.
Nothing more, nothing less.
So it seems fair, more just, and I think it is really. But the legislature changed the law, and so now we work with a system where if you're found to be more than 50% responsible, then you can't make a recovery. But I want to emphasize that you can't. That trip and falls often are, again, things where, especially right after the accident, a lot of times people won't even really want to report it because you feel embarrassed and you kind of hyper critique yourself. I mean, that's one scenario. Then the other scenario is the person that's totally oblivious to, their role in it, because you might have some role in it, but a lot of times it will not be something, if you're walking like through a grocery store, I mean, you're not looking to see. Yeah.
Grocery stores don't put groceries on the floor for you to look. They have them up on shelves.
Right, exactly. And a lot of times there might be situations where they're stocking. We've had several cases like this over the years where they have the pallet in a place it really shouldn't be, that you don't expect, and you trip over it. There's a lot of different scenarios.
I try not to talk about, when we talk about slip and fall cases, I try not to forget to talk about the one case that we had where one of those big box stores said, the liquid wasn't on the floor long enough for us to know about it. And see, here's the surveillance video, or security. It's not surveillance. It's security video to show it. And sure enough, that security video just helped our case more than it hurt our case. Because what it showed was a customer did spill, I think it was a cup of water or something
like that, right? Oh, yes. I don't remember.
In the walkway in front of the cash registers. And it was there for, I think it was 3 minutes or something like that.
I think it was 2. It wasn't long.
It wasn't long. And so if it was just 2, really, I think there's case law that says 2 minutes isn't long enough, or arguably isn't long enough for the
there might be
store
now,
owner.
But
in that case,
they would say that, right? Because that's not what happened right after.
If it said if it's only there for 2 minutes, I think it's like 4 or 5 minutes is what they said isn't long
short
enough.
Time.
Then the store owner can't be held responsible, and so that's what they were saying. Oh, look, it was only on the floor for 2.5 minutes. Yes. But what else did the security footage show?
It also showed the employees of that store, quite a few of them, walking right by.
Including a manager.
Yeah.
He walked right out of this, I don't know if it's the restrooms or the office there, but he walked right by the area.
Yes. And all of these stores will say that their policy is, you're supposed to always be looking. You're supposed to, if you see something, take care of it. And unfortunately with that, and, human nature being what it is, I mean, it's not like it makes them a, quote, bad person. But the truth is, you're operating a store. You're supposed to be truly on the lookout. And our client was rather seriously hurt. I mean, she took a bad fall.
She needed surgery.
Yeah, so it was a situation there. But that's, as lawyers, we try to build a case and advocate in favor of our client's interests. And in this situation, she actually did not do anything wrong. There clearly was substance water, I think it was, on the floor. And there clearly were responsible people that were chatting and socializing and walked right by and just, didn't do a thing.
Right.
So I mean, again, that just illustrates the importance of seeking counsel and not prejudging the situation yourself, because it is an area people love to be lawyers, don't they?
Yes,
over the years,
sure.
Everybody has an opinion about things, but until you have really worked with, and I would even say, the law is like everything else now, so specialized. So our particular area, if you haven't been working as an attorney in the personal injury field, you really don't know. And that's why you need expert guidance on that. But we do love, everyone wants to hear about my case. Oh, Lori, we got another good one.
That's right. Tell me, what case are you working on now?
Exactly.
Yes, I hear that a lot. But other things that we're seeing a lot, I see it now that the bank is downstairs underneath us. I see a lot of Uber drivers, Lyft drivers dropping off Uber Eats and all that.
Right.
I see them driving all the time. In Florida, there's specific case law or laws, actually statutes, that have to deal with rideshare companies such as Uber and Lyft and such. They have insurance requirements under state of Florida, as we talk about all the time. Florida does not require most people to carry bodily injury liability coverage.
Right.
They're not, if the person who hit you does not have bodily injury liability coverage, they're not breaking the law in most situations. However, if the person who hit you is an Uber driver or a Lyft driver, that law changes, right, Lori?
Yes, and they are now required to carry coverage, and they have, the companies that Uber and Lyft have generally done that. And that's very important because you look at the number of Uber drivers on the road who are, just frankly, regular people doing this.
Trying to,
taxis had a small amount of required coverage over the years,
and they still do, but it's
like
significantly.
$100,000
I think it's 100,000 worth of bodily injury liability coverage. And you may say, "Oh my goodness, 100,000! That's so much."
Right.
Not after we talk about a $30,000 emergency room bill and surgery and.
It's not. It's been that amount for as long as I could remember.
Right.
And we're talking about the taxi now. So really, in order to, it's a very positive thing that
it is. Finally, something's good.
Yeah, that you'll have an opportunity to recover, because the reality is so many times people don't realize, because you don't think about it. If you haven't had a situation where you were in an accident, something happens, it was wrong. You feel that there should be a redress for it, and it's an understandable thing. But if there's no applicable, available insurance coverage, then in the normal situation, there's not going to be a way to make a financial recovery. You make a claim against the individual who caused the damage, and if they are, have a lot of assets or something, there would still be a way but you'd have to get a judgment and recover a judgment, and in most situations, that's not going to be possible, really.
It's not gonna, because if somebody had a whole bunch of assets, they would have the insurance coverage to protect them.
They would, exactly, or their assets in ways that you wouldn't be able to attach them. So insurance is really, as much as we complain about it, and unfortunately, it's big business, and I think you'd have to say, obviously, that it's not operated with the injured party in mind like it should be.
Sure.
Really, but at least if there's insurance coverage, and that's why it's so important that the Uber and Lyft and the ride shares do have to have the coverage, so that if something does happen, there's an injury, that there's some ability to make a financial recovery.
Right, and the insurance coverage varies depending on whether or not the Uber driver has somebody in the vehicle or if they don't, but they still have to have insurance coverage.
Yeah, and a significant amount.
Which is, but you still have to prove that the Uber driver was at fault for the crash.
Right.
If you're a passenger in Uber and somebody hits the Uber vehicle, they don't have uninsured motorist coverage, so you can't utilize the liability coverage.
That takes us back to the importance of understanding your own insurance coverage.
100%.
Right. Because if you're injured in that scenario you described, and you have your own insurance, which includes uninsured motorist coverage or liability, I guess it would be the uninsured in that situation. And the other driver, of course, the other driver's at fault if they have coverage. But of course, as we talk about so often, it's shocking how many people have no liability coverage at all in Florida because they're not really required to,
right.
And so as plenty of people do, but it's not necessarily a lot of coverage. It might be $10,000.
Yeah. The last study I looked at, I think it said 2/3 of the drivers in the state of Florida have $10,000 or less.
And you look at what it costs,
Right.
So if you're looking at, you have to have, the PIP insurance that we talk about, the no fault, and then a small amount of property damage liability, basically. But so that you can drive, but that doesn't do anything for you. If you're in an accident, it doesn't do anything for you protecting the person you might have injured if you were at fault, and it doesn't do anything for you if that other person, if you're in an accident that is caused by somebody else, and they don't have any liability insurance.
Right.
So it's not the sort of thing people like to think about. And everything, as we know, prices seem to always only go up on our insurance and that sort of thing. But it is something that people should take a close look at to be sure that they have good coverage for themselves, and then ideally that it includes that element, that a component of uninsured motorist coverage. So if you protect yourself in the situation where other people do not have.
And what I think
insurance.
is also important and sometimes forgotten about is that if you're involved in a crash and there's not adequate liability coverage, you should look at every policy in the household
Yes.
to determine whether or not there is uninsured motorist coverage. Because it's not just your policy.
Right.
It could be any policy in the household.
Yes.
And too many times they say, well, I didn't have uninsured motorist coverage on my policy. There still may be an avenue, and that's why investigation is so important.
Very important. And these actually are, the general situations are a little more routine, but there's so many different fact patterns that can develop. So that's something we always want to look very carefully at. And that is something you want a lawyer investigating for you and looking carefully at, because that's our expertise, frankly, is finding out.
What we eat,
coverage.
sleep, and
Yes.
drink and do, I would not ever be able to fix an air conditioning unit like Dave does, my AC guy, but certainly I can help with a legal problem, especially an auto accident. So you listen to Lori Robinson. She is one of the attorneys at the law firm of Perenich, Caulfield, Avril Noyes. I am Matthew Noyes, and I am also one of the attorneys at that fine law firm. We have been the longest established personal injury law firm in Tampa Bay since 1955. We are here live on Tuesday from 5 until 6 o'clock every week to answer your questions. And when we're not here, but you still have questions, just jump on the podcast and you can find all our episodes on your favorite podcast platform. But we do have about 13 minutes left. And so I do want to talk about something that I think is very important, something that we do with pride, and that's helping people with their Social Security disability claims.
Sure.
Could you, I always say Social Security disability, but it's also Social Security income,
Yes.
SSI claims and SSDI claims.
Right.
Can you tell our listeners, the difference between an SSI claim and an SSDI claim?
And this is the kind of thing I love, that we have our podcasts online, because, it's available as a source of information. If you're thinking, I think the lawyers may have talked about this, or you can check it out on our website, and no one ever understands the difference. And
they don't.
And honestly, probably even after I explain it.
And they shouldn't.
There's really no reason unless you come into it. So Social Security disability is a benefit that is basically your Social Security retirement benefit that you can receive if you become disabled, as Social Security defines disability, which is a situation where, for medical reasons, which could be a combination of things, you are unable to perform substantial gainful activity. Lots of nuances to that.
That's a whole show in itself.
It is.
We'll do that next time.
Right. And then the SSI, which is the supplemental security income, is really the welfare version of that program. So there's certain rules related to having sufficient work credits that are what entitles you to Social Security retirement and disability. And they're kind of complicated. That'd be something to discuss. But sometimes people don't have enough of those credits, or they're not recent enough under the rules that they don't qualify for the disability program, which would be getting their retirement benefit early because they couldn't work. The SSI is a much smaller benefit because it is a welfare benefit, but it's currently like $967 a month. But so if a person, for whatever reason, didn't qualify for the disability program, the medical standards are the same,
Right.
but there is that other program. But they are different only in terms of entitlement. Like a person, many people will ask, well, could I do a little bit of part-time work or something? And obviously, if you're able to work, you don't want any of this, but if you aren't, or you're reduced to the point where you can only do a little bit, then that's not necessarily inconsistent with a Social Security disability claim. You might maybe earn $800 or $1,000 a month or something. Currently, Social Security considers if you earn anything over $1,620 gross in a month, then that would be substantial and you wouldn't qualify for disability. But under that, you could. So in that scenario, you could do that and you still could receive your disability benefit. You could also have many assets, a lot of money in the bank account. We hope you do in that situation. Has nothing to do with disability, but the welfare version is intended for people that actually are quite destitute. $2,000 resources is all they have, kind of thing. So that's a more limited program, but it does, thank goodness it's there in the event that a person comes upon hard times and needs to avail themselves of the program. And we do handle both of those cases. And as I say, the medical standards are exactly the same. Yeah.
And sometimes when we do the application, we may not know which one to qualify for. So you may apply for both.
Right. And you do generally want to do that. But again, complicated rules. If you actually will qualify for disability, ultimately, there might be periods where the SSI would kick in for you. But yes, so that's why you need to be consulting an attorney.
That's right. What's the biggest mistake that people make on their SSD applications, and how can they avoid it?
The biggest mistake?
Yeah. What do we see a lot of? Or just throughout the process of their case.
When I look at the biggest mistake that I think people make is they misunderstand and they think, well, I've got this medical condition and this medical condition and this medical, and they're serious. I had a stroke, but they might have recovered pretty well from it. You've got to go to the doctor and you've got to talk about the limitations you're experiencing from whatever the problem is. So hopefully the doctor can help you, but if not, your medical record is documenting the limitations, because what people don't understand is Social Security is looking at what you could still do even with all the problems you've got. And so that's the problem. People do not get that often. They think, well, I have this serious problem, that serious problem, but it's a medically driven process, so that the records are very important. And many people have difficulty getting treatment if they aren't working, and they may have issues with insurance coverage and all of that. But you must get ongoing medical treatment that documents what your limitations are, not your condition. It does need to show that, of course, but so if you have trouble lifting things, then that's something that needs to be discussed with the doctor. Say you have a back condition or whatever it is, so that the doctor can help, and but also so that there's enough information that it shows what your problem is,
right?
Because that's what Social Security is going to look at. How is this person able to do seated duty? It's very, there are a lot of things they look at, but I would say that to me personally, the biggest mistake is not understanding how important it is to get the medical care and be detailed about the problems you're having, so that it does get into the medical record. And, obviously gives the doctor the opportunity, hopefully, to help. But.
Yeah. And what I've seen as a mistake on the application process is that an applicant would think that they're disabled because of one condition. I had a heart attack, and so I should be disabled. But Social Security doesn't look at one condition. They look at you as a whole. And so they fail to put the other conditions either associated with the heart attack or not even associated with the heart attack.
And that is because the real issue is actually going to be, what are the limitations? And so they think in terms of the serious upsetting thing that happened to them, like a heart attack. But what's going to be important, obviously you're going to identify that, but you're right.
But the obesity they may have that they don't document, the diabetes that they may have.
And again, these are, it's got to come through the medical.
Right. And that's what I was going to say. The second one is they don't list those doctors because of the fact that they're not listing those conditions on their application. They don't list the doctors on the application.
I guess I would say, because maybe what you're driving at, which is, so what do we see? Many years ago, we would kind of get into the process after the client had already filed the application on their own, which you could do. I mean, you can do it on your own. You can go online and do it. But what we found is that it kind of puts you a little behind the eight ball, because people don't actually understand what Social Security is looking for. So they don't list all the things like you're saying, all the different conditions. They don't make sure that the medical is accurate. because they don't actually know what Social Security is looking for.
Right.
And
Social Security will gather the medical records, but only if you tell them where to gather them from.
Right. And, we're talking this afternoon with our legal assistant that does such a wonderful job on our team. We're able to get in there, and if Social Security, they request it, but they don't get it, we can follow up and be sure they get what they need.
That's why it's so important. At Social Security, if you're trying to handle a Social Security claim by yourself, you're making a mistake. You're dealing with the federal government.
Right.
And you don't want to do that by yourself. It's so important. And what's our fee?
Fee is set by Social Security, and it is, you don't pay anything unless there's actually a financial recovery. It's 25%. And they have various maximums that the Social Security sets, but it's all, so if there are back benefits, then the fee is deducted from those back benefits, and it's 25% up to the cap that Social Security sets. But you don't have to worry. You wouldn't be able to. Most people would not be able to hire a lawyer and pay them along the way. So you don't have to worry about that. We work on a contingency, which is just like it is with the auto accident case in a personal injury matter. There's a percentage.
And our percentage is just on the back benefits. It's not, hey, we got your Social Security benefits. You're going to be receiving them.
Oh, heavens no. Right.
Some short-term and long-term disability plans have that, where the attorneys take a portion of every benefit.
Yeah.
We don't do that. It's the attorney's fee is solely based on the back benefits, and that's really it.
Yeah.
Before we wrap up, we hear something that we see all the time in our Social Security cases is Dr. Jones says I was disabled. I should qualify. Why isn't that good enough?
Yeah, in fact, it's almost like a red flag, and it's good.
That's true.
Because to Social Security, because they will say, well, the Commissioner of Social Security, that decision is reserved to them, which is their way of saying, the doctors don't actually know what the standards are for Social Security disability. So they can say, I don't think my patient can work. But Social Security does not care about that. They care about the functional limitations, those limitations. I can't really lift, and my job required me to be able to lift 25 pounds or whatever it is. That's what Social Security looks at. That's why you got to be talking to the doctor so it gets into the record. Now, if the doctor says this person is going to need multiple unscheduled breaks because they've got to be able to rest, they're not going to be able to be on their feet for more than a couple hours, whatever it is. But he or she,
document it,
and it has to be something you've discussed with the doctor. And in that scenario, then the doctor's opinion that their patient couldn't work is what Social Security is going to look at as the reasons why.
Because
those limitations, because that's totally what it's all about. They love to say in Social Security that the treating source is opinion is not one we're going to consider, and they don't.
Right.
They don't.
Well, we've been talking from a physical limitation standpoint, but this is the same thing for a mental disability as well. We deal with a lot of people that are dealing with depression or anxiety or other mental conditions that just prevent them from being able to work.
Right. And those are, by their nature, there's an intangible quality about that. Even more important to be having specific discussions about the problems you're experiencing if you have those problems, so that it does get into the medical record for your psychiatrist or your psychologist or counselor. Very, very important.
Yes. Well, we're going to wrap up this edition of FLA Law on the Radio. Lori, thank you very much for
very welcome.
Again,
always
spending another hour with me.
Always good to be here.
we spend lots of hours together at the office. So that's good. I will be on a boat next Tuesdays, but Jacqueline Bryant will be here hosting FLA Law on the Radio. If you missed something, jump on a podcast and find FLA Law on the Radio. But if you also have questions, call our firm. We're here to help you. The number is 727-796-8282, or you can visit us on usalaw.com. In the meantime, good night, drive safely, and watch out for those who don't. Take care.